Regulation, EU, 2016-679 of the European Parliament and of the Council. Of the 27th of April 2016. On the protection of natural persons with regard to the processing of personal data and on the free movement of such data, and repealing Directive 95/46/EC, General Data Protection Regulation. The European Parliament and the Council of the European Union. Having regard to the Treaty on the Functioning of the European Union, and in particular Article 16 thereof. Having regard to the proposal from the European Commission. After transmission of the draft legislative act to the national parliaments. Having regard to the opinion of the European Economic and Social Committee. Having regard to the opinion of the Committee of the Regions. Acting in accordance with the ordinary legislative procedure. Whereas. Recital 1. The protection of natural persons in relation to the processing of personal data is a fundamental right. Article 8, Paragraph 1, of the Charter of Fundamental Rights of the European Union, the Charter, and Article 16, Paragraph 1, of the Treaty on the Functioning of the European Union, TFEU, provide that everyone has the right to the protection of personal data concerning him or her. Recital 2. The principles of, and rules on the protection of natural persons with regard to the processing of their personal data should, whatever their nationality or residence, respect their fundamental rights and freedoms, in particular their right to the protection of personal data. This regulation is intended to contribute to the accomplishment of an area of freedom, security and justice and of an economic union, to economic and social progress, to the strengthening and the convergence of the economies within the internal market, and to the well-being of natural persons. Recital 3. Directive 95/46/EC of the European Parliament and of the Council seeks to harmonize the protection of fundamental rights and freedoms of natural persons in respect of processing activities and to ensure the free flow of personal data between member states. Recital 4. The processing of personal data should be designed to serve mankind. The right to the protection of personal data is not an absolute right. It must be considered in relation to its function in society and be balanced against other fundamental rights, in accordance with the principle of proportionality. This regulation respects all fundamental rights and observes the freedoms and principles recognized in the Charter as enshrined in the treaties, in particular the respect for private and family life, home and communications, the protection of personal data, freedom of thought, conscience and religion, freedom of expression and information, freedom to conduct a business, the right to an effective remedy and to a fair trial, and cultural, religious and linguistic diversity. Recital 5. The economic and social integration resulting from the functioning of the internal market has led to a substantial increase in cross-border flows of personal data. The exchange of personal data between public and private actors, including natural persons, associations and undertakings across the Union has increased. National authorities in the member states are being called upon by Union law to cooperate and exchange personal data so as to be able to perform their duties or carry out tasks on behalf of an authority in another member state. Recital 6. Rapid technological developments and globalization have brought new challenges for the protection of personal data. The scale of the collection and sharing of personal data has increased significantly. Technology allows both private companies and public authorities to make use of personal data on an unprecedented scale in order to pursue their activities. Natural persons increasingly make personal information available publicly and globally. Technology has transformed both the economy and social life, and should further facilitate the free flow of personal data within the Union and the transfer to third countries and international organizations, while ensuring a high level of the protection of personal data. Recital 7. Those developments require a strong and more coherent data protection framework in the Union, backed by strong enforcement, given the importance of creating the trust that will allow the digital economy to develop across the internal market. Natural persons should have control of their own personal data. Legal and practical certainty for natural persons, economic operators, and public authorities should be enhanced. Recital 8. Where this regulation provides for specifications or restrictions of its rules by member state law, member states may, as far as necessary for coherence and for making the national provisions comprehensible to the persons to whom they apply, incorporate elements of this regulation into their national law. Recital 9. The objectives and principles of Directive 95/46/EC remain sound, but it has not prevented fragmentation in the implementation of data protection across the Union, legal uncertainty, or a widespread public perception that there are significant risks to the protection of natural persons, in particular with regard to online activity. Differences in the level of protection of the rights and freedoms of natural persons, in particular the right to the protection of personal data, with regard to the processing of personal data in the member states may prevent the free flow of personal data throughout the Union. Those differences may therefore constitute an obstacle to the pursuit of economic activities at the level of the Union, distort competition, and impede authorities in the discharge of their responsibilities under Union law. Such a difference in levels of protection is due to the existence of differences in the implementation and application of Directive 95/46/EC. Recital 10. In order to ensure a consistent and high level of protection of natural persons and to remove the obstacles to flows of personal data within the Union, the level of protection of the rights and freedoms of natural persons with regard to the processing of such data should be equivalent in all member states. Consistent and homogeneous application of the rules for the protection of the fundamental rights and freedoms of natural persons with regard to the processing of personal data should be ensured throughout the Union. Regarding the processing of personal data for compliance with a legal obligation, for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller, member states should be allowed to maintain or introduce national provisions to further specify the application of the rules of this regulation. In conjunction with the general and horizontal law on data protection implementing Directive 95/46/EC, member states have several sector-specific laws in areas that need more specific provisions. This regulation also provides a margin of maneuver for member states to specify its rules, including for the processing of special categories of personal data, sensitive data. To that extent, this regulation does not exclude member state law that sets out the circumstances for specific processing situations, including determining more precisely the conditions under which the processing of personal data is lawful. Recital 11. Effective protection of personal data throughout the Union requires the strengthening and setting out in detail of the rights of data subjects and the obligations of those who process and determine the processing of personal data, as well as equivalent powers for monitoring and ensuring compliance with the rules for the protection of personal data and equivalent sanctions for infringements in the member states. Recital 12. Article 16, Paragraph 2, TFEU mandates the European Parliament and the Council to lay down the rules relating to the protection of natural persons with regard to the processing of personal data and the rules relating to the free movement of personal data. Recital 13. In order to ensure a consistent level of protection for natural persons throughout the Union and to prevent divergences hampering the free movement of personal data within the internal market, a regulation is necessary to provide legal certainty and transparency for economic operators, including micro, small and medium-sized enterprises, and to provide natural persons in all member states with the same level of legally enforceable rights and obligations and responsibilities for controllers and processors, to ensure consistent monitoring of the processing of personal data, and equivalent sanctions in all member states, as well as effective cooperation between the supervisory authorities of different member states. The proper functioning of the internal market requires that the free movement of personal data within the Union is not restricted or prohibited for reasons connected with the protection of natural persons with regard to the processing of personal data. To take account of the specific situation of micro, small and medium-sized enterprises, this regulation includes a derogation for organizations with fewer than 250 employees with regard to record keeping. In addition, the Union institutions and bodies, and member states and their supervisory authorities are encouraged to take account of the specific needs of micro, small and medium-sized enterprises in the application of this regulation. The notion of micro, small and medium-sized enterprises should draw from Article 2 of the Annex to Commission Recommendation 2003-361 EC. Recital 14. The protection afforded by this regulation should apply to natural persons, whatever their nationality or place of residence, in relation to the processing of their personal data. This regulation does not cover the processing of personal data which concerns legal persons and in particular undertakings established as legal persons, including the name and the form of the legal person and the contact details of the legal person. Recital 15. In order to prevent creating a serious risk of circumvention, the protection of natural persons should be technologically neutral and should not depend on the techniques used. The protection of natural persons should apply to the processing of personal data by automated means, as well as to manual processing, if the personal data are contained or are intended to be contained in a filing system. Files or sets of files, as well as their cover pages, which are not structured according to specific criteria should not fall within the scope of this regulation. Recital 16. This regulation does not apply to issues of protection of fundamental rights and freedoms or the free flow of personal data related to activities which fall outside the scope of Union law, such as activities concerning national security. This regulation does not apply to the processing of personal data by the member states when carrying out activities in relation to the common foreign and security policy of the Union.